guys, welcome back to episode 6 of Putting the Truth Back into True Crime with FearNothing-QuestionEverything. In this episode, now that all the investigative documents, the photos, the forensic documents have all been released and more people are starting to realise that we may not just be conspiracy theorists after all, I'm going to discuss and prove that Moscow PD went out of their way to use certain language and withhold certain information in order to gaslight the public. I'm going to show you how the courts helped and ultimately how their bias pushed Bryan Kohberger into a plea agreement. There's a lot to dissect here. Would be a good time to grab snacks or to fold that basket of clean washing that's been sitting there judging you for 3 days. If you trust the criminal justice system in the US after this episode, I don't trust you. Enjoy! A lot of people know about the documents that have been released recently by the multiple police departments. But behind the scenes and in the courts, Anne Taylor has been fighting for her life and Bryan's, quite literally, since she was appointed in 2023. She's been met with levels of corruption and bias that I genuinely never even knew was possible. A lot of my original content was based on the court documents, and that's why I've been screaming that stuff from the rooftops for a long time, and also what prompted me to start making videos in the first place. I've been wondering how best to lay this out here without this episode taking like 3 to 5 working days to complete, but there's no good way really. I just hope by the end you've got a better idea of why Bryan would have asked for a plea deal. So let's talk about the only bit of evidence the police have on Bryan, the DNA on the sheath. Bryan's name was located by entering the DNA into the Ancestry database and finding a match. This can often yield results in the tens of thousands. It's then the GG lab's role to narrow it down the best they can until they find a family lineage and hopefully link it to the exact individual. This is obviously a timely process and largely dependent on sites like Ancestry, 123 and Me, etc. for their work. However, when people put their DNA into systems like this, they're asked whether or not they would like their DNA to enter the legal database. If they agree, then it's available for law enforcement to access. If they don't, then their DNA is stored in a database that law enforcement don't have legal access to. I'm unsure whether or not a warrant can be granted for access to such. I imagine so, right enough. However, in this instance, such a warrant wasn't issued. Bryan's DNA started off at the ISP lab. When they received it, they found no match in CODIS, etc., so then they sent it to Othram to start the IgG. Othram had it for around a fortnight until the 9th of December. They were abruptly told to stop work and that the DNA was then being sent to the FBI. I believe when it was sent to the FBI, it had been narrowed down to like 20,000 potential family trees. In their effort to narrow it down, police reached out to a potential family member and asked for a sample of their DNA. They refused. However, within 10 days of having it, the FBI managed to narrow it down to Bryan Kohberger. The defence motioned for a hearing, and in the hearing the expert testified that these results so quickly would mean that they had entered illegal databases, therefore obtaining the DNA illegally and rendering it inadmissible in court. Shockingly, the judge decided to suppress the IgG process, rendering that as inadmissible, but kept Bryan's name, and it was to be referred to and obtained as nothing more than a tip from the FBI. I wish I was joking. Sensing the grave injustice, Bryan's defence filed a motion to unseal the IgG hearing as they wanted the public to be aware of their actions in this case. The judge denied the motion, stating that it shouldn't be unsealed until after trial in case it taints the jury pool. On top of this, the state wanted their DNA analyst, R. Nolan, to testify in court that she believes it is more likely that Bryan Kohberger touched the sheath directly. When challenged by the defence, they argued that she works in a lab and is not an expert in how DNA gets on a surface, which is true, and they backed it up with studies, etc. Riley Nolan even stated herself that secondary transfer in this instance could be likely, but it was more likely direct transfer. That's what the defence had an issue with. This is something she's not qualified to say. However, the state argued that she was, and the court allowed her testimony, allowing her to state how she thought it got there, but disallowing any of the experts to either call it touch, trace, or I believe it was contact DNA. Then there's the vehicle. The next thing they have linking Bryan to these crimes is his vehicle. For a multitude of reasons, the state could not prove it to be Bryan's vehicle. nor could they prove that all of the vehicles in the footage they have was the same vehicle. The defence challenged this and filed a motion asking that the vehicles in the footage not be referred to at trial as suspect vehicle 1 so as to not mislead the jury, obviously because the jury should then be allowed to make up their own mind whether they believe that the vehicles travelling that don't match the times or the distance travelled can be the same as the vehicle they're claiming is Bryan's. The judge denied this motion also. Then there's the mobile phone data, or the movement of the mobile phone data. In the PCA, Detective Payne stated that they had Bryan's device switched off at 2:47 a.m, with it last pinging and traced heading towards Moscow. That's a lie. The defence expert proved that they have Bryan's device on handoff data going from tower to tower for a further 7 minutes, placing him south of Moscow, not southeast, and exactly where Bryan claimed to be. In my other videos discussing Bryan's vehicle movements in detail, I explained that if travelling at 35 miles per hour, you can drive 4.8 miles in 7 minutes. Now that's really important here because for the state to completely dismiss the 7 extra minutes, you're talking that's over 4 miles. That's 4 miles in either direction that Bryan could be further from those crimes, and yet the judge and the court decided that he didn't do it intentionally. The defence challenged this by filing a motion for a Franks hearing regarding the dismissal of the probable cause affidavit. This was among other things. One of the other things on the affidavit was Detective Payne stating that Bryan's phone pinged near the residence 12 times prior to the crimes. The defence expert testified that the cell tower that covers Moscow covers all of Moscow, and that statement is misleading as there was proof that Bryan was just shopping 17 times between July and November, and there was receipts to prove that he was at the Walmart in Moscow and nowhere near the scene of the crimes. The court found that there was no proof that Detective Payne lied about the time Bryan's phone turned off, and that it was more likely just an accident because he isn't an expert and the FBI agent Balance was, but it wasn't Balance that wrote the report and that it wasn't done with any malice. The court also found that when Detective Payne said Bryan's phone pinged off the same tower as or near the residence, because the same tower covers all of Moscow, that he wasn't lying. On those grounds, Judge Hippler denied the defence's motion for a Franks hearing on that matter. So you've got a lead detective that lies about the location of a mobile device belonging to the main suspect to intentionally place him last in an area that he was 7 minutes prior to driving further south of Pullman, potentially solidifying the suspect's alibi, and a judge who doesn't believe that 7 minutes is that big of a deal when dealing with the suspect's whereabouts in a quadruple homicide anyway, and that the detective didn't write the initial report, so the error must have occurred due to that. We've got the same lead detective lying in the same report about where their suspect was the night of the murders and multiple times prior in their probable cause affidavit, purely just to deceive the courts and the public into believing that the suspect was stalking the victims, and a judge that thinks it's nothing more than human error. Same detective, more than one instance, both times human error, both things playing a massive part in Bryan Kohberger's arrest, and both times a judge failing to act on behalf of the defendant in his constitutional rights. It won't come as a shock to you to learn that Detective Payne is no longer a detective. Too little too late, in my opinion. We've got prosecutors allowing lab technicians to testify on DNA transfer to mislead the jury, and a judge allowing it, but the same judge not allowing the hearing on the suppression of the IGG to be unsealed because it might show how corrupt and biased they are. Because it would jeopardise Bryan's right to a fair trial and could potentially take the jury, blah, blah, blah. This isn't even the half of it. In the next episode, I'm going to go through the alt-perp evidence, the 911 call and the text messages, the description of bushy eyebrows, vague and undisclosed expert testimony, the 40-page motion to continue, and ultimately the straw that broke the camel's back, forcing Bryan and his defence into a plea agreement. Thanks for tuning in. If you liked this video, please give it a like and subscribe. Was any of this a shock to you? Let me know in the comments, and I'll see you next time.